Hi, everybody. It's Linda Gould from Democrats Abroad Japan, and I'm here today with David Litt. And David, I'd like you to just give a brief summary, if you can, of your history with the court system.
Sure. I'm a professor here in Tokyo at Keio University in the law school. And for many years, I was a practicing business lawyer. So my history with the courts goes way back to when I graduated from law school. I clerked for Judge Goodwin on the Ninth Circuit Court of Appeals, who was the chief judge at that time. And then I clerked for Justice Anthony Kennedy on the Supreme Court of the United States in 1990-91, which was, I think, his third year on the court. And as we know, he's just announced this summer his retirement from the court.
Yeah.
So,
Uh, I know so little about the judicial system, so I wonder if you can just give me a short explanation about what a clerk actually does in the judicial process and in a law office. Or
sure. I think it's a little bit different based on the level of the court. In a trial court, a clerk is probably doing different things, dealing with lots of motions that come before the court, than at the courts of appeals and the Supreme Court, where it is it's a much more it's a slower pace. Basically, cases come to you after they've already gone through the district court and there's been a decision. Sometimes there's an emergency appeal, or there's a case where someone wants an injunction or a temporary restraining order, and it has a very fast turnaround. The Supreme Court, when I was there, we would get lots of requests for stay of execution in capital punishment cases. They always end up at the Supreme Court, or they did in that era. But most things are on a very sort of set calendar, where the appeal is lodged. There's many months for the parties to get on both sides to get their briefs filed, and then the case is scheduled for argument. At the Supreme Court, there's a separate step where the court actually chooses which cases it wants to hear. Mm-hmm. And so in the appellate courts, you're involved in, the clerks divide up the cases and help the judge prepare for the argument, and then help the judge draft the opinion. Is very common. At the Supreme Court, it's basically the same thing, but you have this extra step of the clerks being involved in reviewing all of the requests for a hearing, petitions for certiorari, and writing memos. At the time I was there, 7 of the 9 justices participated in something called the cert pool, where one clerk from those 7 chambers would write the primary memo that would then get circulated to all the chambers. Mm-hmm. On the arguments to whether or not to hear a case.
So then, if in September we'll be dealing with a Supreme Court nomination. So if you don't mind, for now, I'd like to focus on what you did as a Supreme Court clerk with Justice Kennedy. When you say you collect things for the arguments, does that mean, is that when he has already made his decision and he just wants you to find law precedents that support that? Or is it more that you also hear the case, or you see what's presented, and then you and the other clerks go and scatter through all the laws and try to find something that's relevant as more of an advisory capacity?
It was a little bit different. Again, on the Ninth Circuit, some of the cases had excellent lawyering, other cases had not so good lawyering. And so it really depended on the case, how much, if the lawyers had done a very good job of presenting the arguments and briefing the case, then it's quite easy for the judge. Then the cases, it's a question of choosing amongst the arguments. If they're well presented, then the issue is very focused and it's easy for the judge. By the time cases get to the Supreme Court, they tend to be very professionally presented, and in the major cases, there are lots of amicus briefs filed. In the, for example, in the case on the Second Amendment, you'd get the linguists of America filing a brief on the meaning of the commas in the wording of the Second Amendment, and you get very focused. Additional information is already given to the court. So the clerks, we would, for Justice Kennedy, we would write a short bench memo to the justice explaining our view of the case. And we would attach, in addition to the justice having the briefs and everything, we would prepare a briefing book with other material for him to look at.